Hello and welcome to Number 8 Chamber's latest immigration conversation, a series that we've been doing looking at current issues in immigration law. Today I'm joined with Stephen Vokes, who is the head of the immigration team at Number 8 Chambers, and Alex Barnfield, another member of the immigration team who does a wide variety of work within the immigration field. We're going to talk today about two cases predominantly, PS Christianity Iran and AK Afghanistan, which deals with the Article 15C risk for those who return to Afghanistan. This is meant to be an informal chat between the three of us. It's not meant to be any kind of guidance in terms of legal advice, just talking about the issues that have arisen in these cases that we're going to talk about today. So if I can turn to you, Stephen and Alex, about the case of PS Christianity, perhaps Stephen, if you could summarise it for us.
Yes, this is the third time in this century the Immigration Appeal Tribunal and then the Upper Tribunal have actually looked at the risk in relation to Christianity in Iran. And it splits simply into two forms. One, asylum seekers who come here and claim to be at risk because of their Christian activities or their Christian worship in Iran. And secondly, those who come here and become Christian converts, in refugee terms, they're refugee surplus. And essentially, the first case to deal with this is a case where I played a leading role on behalf of the appellates, a case called FS Iran, and that was back in 2004. And essentially, that said that, in fact, more active converts, proselytizers, evangelicals, and so on were at risk, paragraph 189. That was confirmed in a case called SZ and JM in 2008, which essentially said the same thing and endorsed the findings in FS. However, the recent country guidance case of PS Iran, 2020 UKUT 46, has actually looked at the issue again. And essentially, it asks a number of questions. One, is the person a Christian? Well, rather reasonably likely to be a Christian. And I think Alex may have some input into that further on. Two, essentially, would they conceal their religion? And that is based on, of course, cases like RT Zimbabwe, HT Iran, because if they would conceal it because they were scared of the government, therefore, essentially, there's a persecutory risk to them. But that's going to be distinguished from other reasons, such as societal disapproval of the religion. They also comment, essentially, even if one makes a false claim, it's still necessary to essentially look at what would happen. In other words, in essence, the risk on return. And essentially, they talk about whether there had been adverse previous contact, whether, in fact, their social media profile was such that they had been seen to actively promote Christianity, and so forth. One of the points I wanted to deal with, though, is this. Essentially, originally, FS actually said that there could be additional risk factors. For example, if you were a single woman. Now, one wonders how that plays into PS, because it's not actually that clear. What PS tends to do is actually look at essentially previous contact with the authorities and essentially were they connected to persons of interest. They don't actually say that And I'm considering here, for example, whether if you were of Kurdish ethnicity, for example, that would be an additional risk factor which would bring you, regardless of whether your claim of being a Christian was seen as true or false, the fact that you actually avowed Christianity, whether that would put you at risk on return. So therefore, I do find that there's essentially a bit of blurring going on here as to the factors which would place you at risk. But clearly, there are essentially the view, and I consider it shifted somewhat, in that the fact of being a Christian itself would actually put you at risk, rather than having to prove activity, evangelical behavior, and so forth. And so really, it comes down to the first question for all practitioners is it reasonably likely your client's a Christian? And there's a number of factors involved. And I think that MH, which Alex is going to talk about in a second, sort of comes into play here.
Yes, I think Alex was going to talk about the case of MH, which although is not country guidance and was dealing with procedural issues in the tribunal, also has some interesting comments to make about evidence from churchgoers and people who are in the leadership within the church and how to approach that. What does MH tell us about that, Alex?
Yeah, so MH is, it deals with it. Weirdly, it also is a case that deals with the slip rule. But the bit we're talking about today is to do with church witnesses. And MH was a lady who initially more fully relied on political opinion or imputed political opinion. But then when the matter came to further representations and then eventually to the upper tribunal, her conversion to Christianity was principally the position she relied on. And she sought to rely on the evidence of a member of her church's congregation, referred to in the case as Dr. MN. And she sought to establish that the evidence of a fellow congregant who was willing to come to the tribunal and give evidence that this was somebody who they felt was genuinely a Christian and had started to obviously attend church, but go through the process of becoming and then living as a Christian, was akin to or was expert evidence or should be treated as such. And so the upper tribunal looked at that and with it discussed the Scottish case of TF and MA, where similar evidence had been referred to as a species of expert evidence. And the upper tribunal's conclusion in the end in MH, forgive me, was, and we'll have a brief chat about why, but essentially was in the end was that such evidence was deserving of no more weight than other evidence. And in any event, weight is a matter for the tribunal hearing the case to attach as they see fit. Why was that? MH, the upper tribunal in MH, first of all looked at a few things. It said, first of all, reminded us that in the tribunal, evidence that might not be admissible elsewhere in the civil courts or otherwise is in the tribunal under the tribunal rules, Rule 14. And then sought to draw a distinction between, for example, doctors called to give evidence as to lesions on the body and the sort of evidence that Dr. MN was able to provide to the tribunal. And to quote from MH, the tribunal said there's no recognized methodology by which the genuineness of an individual's conversion from one faith to another can be measured, nor can that question properly be categorized as belonging to a field of knowledge or science. So there, the tribunal is setting up a pretty high bar for where they say expert type evidence needs to be. That's paragraphs 40 to 41, where they again refer to TF and MA. And then at paragraph 44, they say there's also a further reason why such evidence shouldn't be described as expert evidence. And that is to draw a distinction between the obligations of lay witnesses as opposed to experts. And they say lay people who are seeking to give factual and opinion evidence on matters of faith are not experts who should be properly expected to comply with the sorts of obligations that professional experts in their field with that body of science or knowledge or facts behind them should be. So they draw that distinction. They also bring up Mr. Justice Gilbert's oft quoted phraseology from our essay, where he said, talking about whether he felt he was able to judge people from an entirely different background and who had experienced a conversion and whether he was best placed or a court was best placed to judge that. And what the upper tribunal said was it's entirely permissible for a judge to turn his mind to a whole range of additional considerations, including not least the timing of the conversion, the individual knowledge of the faith, the opinions of other members of the congregation as to the genuineness of the conversion. Although that's obiter, they said it was a obiter but necessary comment for them to make. And so ultimately they conclude that the evidence is admissible and is worthy of respect, but is ultimately no more deserving of particular weight than anything else. And of course, weight is a matter for the tribunal hearing the case to attach. So, yeah, so certainly not helpful in the sense of it doesn't elevate that evidence that we've often called in such conversion cases, but a statement of the upper tribunal's view anyway.
Yes, I mean, I was somewhat intrigued by their view of the opinion of other members of the church. It seems to me that on a practical basis, you either turned up, quote, mob-handed at court with a brace of 10 vicars in a row and just said, yes, we've all spoken to this man and blah, blah, blah. Or I think the court's being pragmatic about this, would accept statements from other leading members of the church. And I think that must, in my view, be the way to go. That it's not, and I don't think pragmatically the tribunal would want to hear from 5 or 10 witnesses from that church, but at the same time, we would have to have their statements in a practical way saying what they know about this person's conversion. And I think it's also very relevant to consider that all is not lost, even if the tribunal find that in fact essentially somebody's pulling the wool over the requisite church's eyes and is actually a Christian convert, not through belief, but for pragmatic reasons, i.e. to get a refugee status, because you still have to have a look at the risk on return, at the so-called pinch point, see other Iranian cases, because it's clear that the tribunal believe the very fact, and you will get interviewed at the airport, the fact that you have actually taken place in Christian activity would at the least make them suspicious. And then we get back to what I was saying earlier about additional risk factors. So in summary, for me, what actually the case demonstrates is a drilling down into the sort of factors which would place you at risk, and a welcome extension in the sense of just being a Christian in Iran, and essentially whether one is a member of the house church, which would be the only relevant organisation, or a Christian convert in the UK, would place you at risk if you wanted to practice your religion. And that is essentially, for the reasons I've already said, is a step forward. And that links in, I suppose, with what Alex was saying about MH and the way you assess whether somebody has a genuine Christian belief, a genuine Christian faith. I don't think I could really add anything to that.
No, that's very interesting. Going through the country guidance of PS and the factors that we need to all be conscious of. And I think the other topic we're going to talk about was Afghanistan country guidance as well. Would you like to give us a summary of that, Stephen?
Yeah, essentially, what the latest case of AS, Afghanistan, deals with is, in fact, the usual question. I say usual question because it was brought up first in a case called AK Afghanistan in 2012, which I did on behalf of the appellant, and Emma did too, essentially about risk. And they start off by saying that essentially there's generally no risk of indiscriminate violence. That's the Article 15C point. And in fact, they actually say AK, the case I did with Emma, is actually correct on point. But then they really, and the other thing, of course, which AK did, it actually looked at Kabul and whether internal relocation as what is essentially an IDP, internally displaced person, would be unreasonable or unduly harsh. And essentially, they found really relocation was essentially open to all. Although there is a caveat in paragraph 243 of it, that's of AK, stating that one would always have to look at the situation of the individual circumstances to see whether it was reasonable or not.
And I think it's fair to say that in AS that's been developed quite a long way, dealing with the individual circumstances, hasn't it?
Yeah, I mean, that is what I would say is the heart of AS. What they've done is actually put flesh on the bare bones of what the tribunal found in AK. And there are all sorts of factors one should take into account. I consider the main one being what sort of connections, family or clan connections, the appellant might have in Kabul, and also what kind of support network he and if they're predominantly men, would be able to build up. I might add, for individual women, certainly if they have no male support, essentially it would be unreasonable for them to, it's well established in another country guidance case, for them to return to Afghanistan anyway. But just upon that, basically it's whether they're aware of cultural and societal norms, the importance of the support network, and in fact, those and how long they may have been out of the country and how old they are.
Health factors, of course, come into it, don't they, quite significantly in looking at employment opportunities that are available.
Yeah, they say essentially if you can do manual work, you're generally all right. My view is that, as I said, there's more room for manoeuvre. But again, building on AK, they do say in AS, the starting point would be that it would not be unreasonable for a young, fit man to actually relocate to Kabul. And that's the starting point. Some people on social media seem to assume that, in fact, it's enough that you're an Afghani asylum seeker because you must have other features which would put you. But it's necessarily the case because, as I say, that's not the starting point, that a young man would be at risk. And as I say, the overwhelming majority of cases we deal with are young men from Afghanistan. I would just throw in one point. Of course, a lot of the talk in AS, because of course it is said safety of Kabul, doesn't actually deal with those asylum seekers who may claim that per se Kabul is unsafe for them, perhaps because of family connections with the Taliban or ISIS or whatever. And obviously it seems to me that it follows, if it's unsafe for you in Kabul, it's unlikely to be safe for you anywhere else in Afghanistan. But the tribunal do not deal with the point directly.
No, I mean, they make some interesting points when looking at the safety of Kabul, don't they, as the first element of the internal relocation point, that there are actually elements or areas within Afghanistan with a much higher civilian casualty rate per capita than there is in Kabul, for example. And they make the point that other areas may in fact be even more dangerous, but they don't really give us any guidance in respect of that.
Yeah, that's right. The case, in my view, is not a game changer, but what it does do is it opens the window of opportunity for asylum seekers to demonstrate in their particular circumstances. It would be unjustifiably harsh, sorry, unduly harsh, wrong point, unduly harsh, or indeed unreasonable for them not to go and live in Kabul. So essentially, I suppose, like all asylum cases, you've still got to actually prove that, one, you have a real risk of persecution in your home area, and two, it would be unreasonable for you to relocate. Yeah. But I take the point you make, Emma. I think if you are from Kabul or its environments, possibly even Kabul province, you can't be expected to actually relocate elsewhere in Afghanistan. Although, of course, they do not say any place in Afghanistan shows an indiscriminate risk of violence to an Article 15 standard.
No, I mean, they're quite clear on that point that nowhere's at a 15C standard. I just think it's interesting that they not, when they're doing the comparisons, or they don't really do comparisons to be fair, but when they make the point about Kabul and whether there is a risk there, they look at the facts and say, well, actually, there are areas that are more dangerous. But on the point of internal relocation, you don't ever really see it argued by the Home Office that your client can go elsewhere. They tend to say you'll be okay in Kabul.
That's right. And I think you see their views on Kabul come from, of course, the numbers of IDPs, something like 2 million IDPs in Kabul. Yeah. And that's why one supposes they will say, well, if there's 2 million people living there, it may not be ideal, but it's not unreasonable.
Yeah, and especially when comparing with the norms of life in Afghanistan.
Quite. I don't think I really want to add anything to that. I don't know about you, Emma.
No, I think that covers AS Afghanistan. As you say, it moves us on slightly from AK Afghanistan and gives you that little bit more wiggle room almost to argue that your client is going to be within that category who can't reasonably relocate. But I don't think there's much more to say.
Great. Well, thanks, guys. Nice to speak to you both.